Hi, everyone. Harry here to try to explain the whole fairly labyrinthine situation with the January 6th trial that now different pieces of them, I've never seen anything quite like this, reside at the district court level with Judge Chutkan, at the Court of Appeals level with a panel there, and at the Supreme Court level with an expedited petition for certiorari. So let me go through each of them. Now, first, this is all about immunity. And immunity has always been the big ticket item for Trump because it's, I think, a loser for him, but much more weighty and a possible winner than any of the other sort of garbage motions he's been throwing up there. And then second, and maybe even more importantly, because immunity motion automatically affords him a appeal interlocutorily, which means everything freezes in the district court, and he gets to take it up now with all these other motions that he'll likely lose. If he's convicted, then they become things he can raise on appeal. But immunity, he can actually stop the music in the district court and move up to the Court of Appeals. That is because immunity is a right not to be subject in the first place to the rigors and stresses and costs of trial and litigation. So it doesn't make sense to say, well, you can be convicted first, and then we'll see if you should have had immunity. If he's entitled to immunity, he's entitled not to stand trial in the first place. All right, let's march through each level. It's pretty interesting, and it's quite a tangled web. All right, Judge Chutkan. She yesterday issues a 3-page opinion saying, Donald Trump has appealed my denial of his immunity motion, which indeed he has. Recall, I think this was about 2 weeks ago on a Friday, the Court of Appeals issues an immunity opinion against Trump in a civil lawsuit, the Blassingame suit, and within a couple hours, we see the denial of immunity by Chutkan, who obviously had drafted it and was waiting for that opinion to come down. That opinion was only helpful to her, and so she issues hers, and it's both methodical and careful, etc. Not full, but peppered with some pretty good, red meat quotes about how we don't have kings in this country. But it's also has the kind of analysis that I think is designed to survive Supreme Court review. It goes through, as the Supreme Court might, the text, history, and structure of the constitutional provisions and concludes there is no absolute immunity, which is what Trump had asked for. Okay, so she now holds, Trump files a notice of appeal for that ruling, and she holds yesterday that notice automatically divests me of jurisdiction over the case. I now, the case file, as it were, the appendix, will go up to the Court of Appeals. It's not mine anymore. But a couple caveats or asterisks. The first and most important is that the Department of Justice came in and said, look, he's bringing this motion. He actually could have brought it a couple months ago. He's now bringing it, and discovery is well underway. He's already gotten the advantages of discovery. He's already had to absorb the costs of it. So, Judge Chutkan, keep discovery, continue to preside over it, let it go forward, but simply make clear that the trial can't proceed as long as this is on appeal. It would have been terrific for the DOJ and the country, because what it would have meant is the case developed apace, as it will need to do if Chutkan's motion is affirmed and there is no immunity and it comes back down to her. We would have gone through discovery deadlines, etc., just not to trial. She says no. Her reading of the law, and she's a very, I think, solid and law-abiding judge, is I don't have jurisdiction over the whole thing, including discovery. That has to stop. And that's, in a sense, the headline of all these developments, because it means that as of today, not only is the clock suspended down in in the district court, but each day pretty much corresponds to a day of delay in the eventual trial. She had motions and deadlines that moved up to a pretrial conference and the trial. It's hard to see now how, if and when she gets it back, she doesn't just restart the clock, including where they are in discovery. If she tried to say, oh, it's so important that we get this done quickly, therefore when I know I gave you 3 weeks before, but I'm going to give you 1 week, Trump would jump up and down and go apoplectic, and I think with good reason. He'd say, look, this was already set. This is not a legitimate reason to cut it back just because, you Chutkan, you're the one who said we don't want to be too focused on the election. We're just going forward as we would with any other litigant. And so therefore you can't chop the clock to make up for this lost time. The lost time is lost time. So what I anticipate will happen, and is already happening, is that until she gets the case back, the delays, the days that are clicking by, will simply be added to is it April 4th trial date? And so I think we are looking, bottom line, at a delay of 1 to 2 months. Now, that still permits ample time to have a jury trial completed before the election, but it probably means that a jury trial occurs when Trump basically has secured the nomination, maybe even at the time of the Republican convention. So, the stakes get higher because it's literally the sitting Republican candidate. And of course, he'll jump up and down and scream, you can't do anything now. It's election interference because we're now in a general election and that takes priority. The American people have a right, blah, blah, blah. Okay, that's *1 to Chutkan. And what I suggested is maybe the most important of the whole ball of wax, which is to say we have a delay now because discovery isn't going forward and we'll have to recommence. The other asterisk to note, she didn't give up the entire case because she reasoned in her short 3-page order that she needs to keep the gag order and she needs to keep the ability to redress discovery abuses based on orders that have already come due. You can't really give that to the Court of Appeals. So she's making it clear if he violates the gag order, which has been affirmed, that's going to come to her. It's going to be she who says to the lawyer, get your client here, and boxes his ears and the like. Okay, so that's Chutkan. She gives it up, including litigation, in a way that will cause a delay, but she holds on to several things, most importantly, the gag order. All right, next level, Court of Appeals. The legal act that divested Chutkan of jurisdiction was Donald Trump's filing of a notice of appeal, which happened after the expedited petition for cert, which was last month. Well, I'm sorry, the notice happened before, but all the events have happened since. But just to cover what's going on there. So there's this appeal. It's going on. The Supreme Court hasn't done anything. They've just agreed to think about it quickly. So it's now in the Court of Appeals. And Jack Smith asked the Court of Appeals, do an expedited schedule yourself. We need this quickly. And the Court of Appeals has been very sensitive to that issue. and they're kind of all over it. So the panel, which is a strong panel for Smith and a bad panel for Trump, it's got 2 Biden appointees and 1 George H.W. Bush appointee. They agreed that we're going to do an expedited briefing, and almost certainly it would mean an expedited handling of the case. So they yesterday issue a schedule that is warp speed by normal appellate time, which you measure in the years. This will be the days, maybe weeks. And it says, okay, expedited schedule. By the way, Donald Trump came in and said, don't do it expedited. What's the big rush? And you're going to make my folks work over Christmas. So they indulged him. They made the first deadline before Christmas. He's got to get his appeal papers in by the 23rd of December. Then the DOJ answers, I think by the 30th, and he's got to then reply by the 2nd of January. At that point, things are totally set up for them to, if they're on the warp speed schedule that I think they will be on, to set oral argument like in a couple days, say the 4th, and to issue an opinion maybe very quickly, maybe as short as a week or 2. At that point, if they were to affirm Judge Chutkan and remand it back to her, she gets jurisdiction again. The clock starts running, and we've lost less than a month. Okay, but now we have the ultimate wild card of the U.S. Supreme Court, because the motion that the DOJ made was directly to the Supreme Court saying, take this case, take the question of immunity before judgment. That at the time meant Chutkan, but it equally means the Court of Appeals for the District of Columbia Circuit. So that is still up there. Their motion saying, A, expedite this, and B, decide whether you want to hear the issue of immunity. And so they have, they've got the brief that the DOJ has filed saying, here's why you need to hear it, and pronto. And Trump has to supply his, and nothing about the Court of Appeals maneuvers changes that by next Wednesday. And he's going to give his reasons. Either he's in a box, it seems to me. How can he tell them it's not cert worthy, this issue of immunity that he's basically rolling all the dice on, more or less now? But he could try to say it's very important, take the case, but don't take it so quickly, give us ample time. It's very important. You need to consider it methodically, etc. But, they could, so far they seem pretty attentive to what the DOJ is saying about trying to do it quickly. And, they're not idiots. They can use a calendar. And if it goes a few months as Trump wants, now it's in the Supreme Court when the election is in full flower and it's on the court. The idea of delaying the whole thing, and let's say the court actually decides against Trump, but does so too late to try him, so they're tagged with the delay and with having done this huge solid for him. And even though they're not holding for him, are they going to want that? You can just be sure that the court is aware of the calendar. Now, what will be a very interesting strategic question, I know this is a lot of litigation strategy, but it's super interesting, and I think it's a singular situation in my experience. Come the time, so Trump gives his response next Wednesday, then we need the DOJ to reply why we've heard what he has to say, and we still think you should take this petition, take up the question, and issue a very expedited schedule. But at that point, the DOJ will know more about what's going on in the D.C. Circuit. Might know, for example, if they've decided to have an expedited hearing schedule, and might be able to surmise accurately that they're going to try the case quickly. So that'll be a very important reply brief on petition for cert. Maybe they say to them, you know what? Take a deep breath. We'll see you in a week or 2. It still would be able to be less time because they'll try to cleave off all the time that Trump would otherwise try to use of taking, if he loses in the D.C. Circuit, trying to get the whole en banc DC Circuit to change it, taking all the time he can for filing a petition. Instead, the DOJ's petition can be revived anytime. So they might just stay the course, just say, look, we know this is coming out soon, but by the time you get the papers, you'll have it. So it's still super important. Still try to decide right away if you want the petition for cert. Or they might say, okay, let's see what the next few days bring. So that's a very interesting question to them. And now, up to the Supreme Court. They still have in front of them this very rare device asking them to take the question of immunity before judgment. That means before the Court of Appeals is finished. And, it so happens that now Chutkan has. So it's still in front of them. They can still grant it and grant expedited treatment. So they could, as of, before the Court of Appeals is held, especially if the DOJ urges them to do it, say, okay, we're going to take the case, take the question, so we don't even need to hear from the Court of Appeals. It's ours now. And this is one of those rare instances where under Rule 11 of our rules, it really makes sense to go forward. A good reason not to do that is to have the benefit of whatever opinion or opinions, let's say the George H.W. Bush judge dissents, that the DC Circuit, very well-respected court, gives. Because if they, take it right away, it divests the Court of Appeals of jurisdiction. So maybe at that point, they hold it for a little. They want to have the benefit of the District of Columbia treatment. Indeed, if they think it's excellent, they could deny the petition for cert, which would bring the whole ball game to an end, because they could think, the DC Circuit has basically said what we would say anyway, or close to it, and we can leave the law. Always, they're not just thinking about the litigants, but the law where it is. Okay, you with me? So at the Supreme Court level, especially depending on what's happened in the Court of Appeals, it's still live, the petition for cert before judgment. It'll really matter what the DOJ urges them to do. And they could now just kind of wait and just take the issue if they want it. Still, they'll have a motion for expedited treatment by DOJ, almost certainly opposed by Trump. What's the big hurry? And so it still seems to me we're on this crazy loop-de-loop from, district court to Court of Appeals to Supreme Court. It's all, with each court, but no court, etc. But it still seems to me most likely this is headed to the Supreme Court fairly quickly. And while it's there and until it's decided, the days that are clicking by will, in effect, delay the onset of the trial in the district court. And that's assuming, of course, that the Supreme Court either affirms the immunity holding or decides not to take the question. If it takes the question and holds for Trump, that's ball game. And it's the end of the 1-6 case because he's immune. It would still leave cases involving conduct after he was president. That includes the Mar-a-Lago case. Cases before he was president, that includes, say, the civil defamation case. But it would be, a huge body blow, and the Supreme Court would own it the way it owns, Bush v. Gore, or in a different way, owns U.S. versus Nixon. Which I'll close with this: the guy who's the center of the court now, which shows what a very, very conservative court it is. Justice Kavanaugh, the man who's most frequently the justice in the majority, has really extolled U.S. versus Nixon as a great moment for the court, all of which is some modest clues, sort of Kremlinology we're doing, that the court, when it gets this issue, will rule against Trump. But, a lot of steps that some of them could be elided over. Some of them could expand. Quite a lot going on. But I think, you pretty much now have it all. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.